Well, good afternoon, everybody. Welcome, welcome. We are just waiting for the Latah County Superior Court to go live today on the defense's fourth and fifth motions to compel production of evidence. So these requests, these have been really shrouded in secrecy pretty much from day one, and that kind of got a little bit of a Streisand effect when the state then went and moved to close these hearings to the public to basically exclude us from the process so that we don't know what these motions to compel are about. That was the last hearing that we had, and the judge had initially said yes, the hearings were going to be closed, but has subsequently reversed course. We learned through that hearing that in general, a lot of this information that's being sought out is dealing with location information. It's dealing with cell site data. It's going to the real heart of the probable cause affidavit and the evidence that was used to support the inference that Bryan's phone was moving in one place. The white vehicle that was seen on video was moving in the same place, that these things corresponded and that therefore the vehicle could be positively identified as Bryan's vehicle, and it could place him outside the King Road residence at the time that the murders were being committed. So the defense is clearly chipping away at that piece just bit by bit. They have their own defense expert that they've hired, Cy Ray, who's a former FBI agent specializing in cell type of forensics. So that's who I thought our witness was going to be today. This hearing that we have, it's not the full hearing on the motion. It's just a hearing to take testimony from a witness relating to the motion. But the actual argument on the motion to compel is not going to be until next week at 10 o'clock, same day, May 30th. So I'll be here for that too. But what we're going to hear today is just witness testimony. I had thought it was going to be Cy Ray just because that seemed like the most logical prospect to me. But the word on the street, rumor going around, lots of multiple reports now are that it is going to be Moscow police detective Lawrence Mowry. And if that name does not ring a bell to you, you may not have done a deep dive into the many documents that have been filed in this case, including specifically a lot of the search warrants. Mr. Lowry is the basically digital forensic detective for the Moscow Police Department. So he's the one who has requested and obtained all of the information that has gone to the Moscow police from places like AT&T, Google, Verizon, T-Mobile, from app-based companies like Spotify, YouTube, TikTok, all of these things, they have Mr. Mowry's name on them. So this is significant because one of the questions we had coming out of the last hearing, when we learned just sort of what the general dispute is concerning, but we don't know real specifically what the problem is, why some of this stuff isn't being turned over. We know the FBI final cast report has not been turned over. That appears to relate to a TUI process that is basically they're demanding in order to be able to release that. But the question has always kind of arisen, what does the Moscow police or prosecutor have versus what did the FBI go and get independently? Because with the discovery obligations, there's a fairly big distinction for a lot of these different categories of information, depending on whether it's something that law enforcement actually has, the local law enforcement actually has, or whether it's something that they would need to go get. So if the FBI has it, unless it falls within a different, fairly specific category of information, it's not necessarily required to be disclosed in discovery. But if the law enforcement and Moscow police have it, there's a much broader category of information that they're required to produce. So I was going back and looking through a lot of these warrants to just kind of refresh myself with, well, what did they get in the first place? What do we know that they have? And What could this possibly be pertaining to? And we don't know. Of course, we're going to find out. But as I said, we know that Detective Mowry is like the key guy in charge of getting all of this digital forensic stuff, and there has been quite a lot of it. I mean, quite a bunch of different warrants going out to the same service providers for different types and categories of information and stuff like that. But there is one warrant that I've been keeping an eye on for a while, because a lot of these warrants were originally sealed, especially the ones before Bryan was even arrested. Obviously, all of that stuff stayed under wraps. But some of them, since then, quite a few things have been unsealed, and we've been able to see the process, specifically, what they've been looking for. A lot of the information's redacted, but we can see, for example, they went to Google to get Bryan Kohberger's account information. They went to Google to get Kaylee Gonzalez's account information. So a lot of that information has since become public. But there is one specific warrant that is still sealed, and it's the one that interests me the most, because it was one that they sought back in November of 2022, still in the investigative stage of this case. And it has been sealed since December 1st and remains sealed to this day. And it's a general warrant to Google that doesn't really, the information that we have is just the motion to seal and the order sealing. So we don't really know what exactly that's all about. And so I have been entertaining for quite some time the possibility that this is a geofence warrant. So let me explain what that is. A geofence warrant is a warrant. It's almost always to Google, because they're the ones who collect most of your location data from your phone. If you have your location history turned on and you use apps or other services on your phone that use Google's location services, then that data is going to Google. And so it's a fairly novel investigative technique that's been used for law enforcement to go to Google and basically say, here's a geographic area. We can describe it with GPS coordinates. Send me a list of all of the devices for which location data was sent to you within this geographic area during this specific time frame. And so it's basically a way for them to capture all of the devices within this geographic area, at least if they're, sending location history, location information. They can get the list of all of those devices in that geographic area for that time frame. So this was a very cutting edge and kind of hot investigative technique for quite some time. Really would have expected it to be used in this case, given that, they didn't seem to be any real obvious leads. It was going to be a situation where we needed to narrow down who's in the vicinity. Kind of went unsolved for quite some time. So just a technique that wasn't going to shock me if it turned out that's what happened. But there are issues with that legally that have since emerged. They have been challenged from the inception because they don't meet the Fourth Amendment standard of particularity, which is basically you don't get to do general searches. You don't get to just sort of, basically a dragnet search is what it's called. You have to have some particularized suspicion of an individual in order to conduct a search that gives you their personal information. And so a geofence warrant, it's not specific, it's not targeted, it's very, very general. Everybody who is in that area is going to be subject to it, whether they obviously have any involvement in the crime or not. So it's been something that defense attorneys have been concerned about pretty much since we found out they were happening. But it has been very slow to work its way through the courts. And it was only at the beginning of this year that the First Federal Circuit Court took a look at geofence warrants and said, yeah, you know what, you're right. These are constitutionally problematic. They don't meet the Fourth Amendment standard. And so it was found to be unconstitutional. So that would certainly pose some legal issues in this case that would give rise to motions to suppress, the kind of thing that Anne has been suggesting is very much on the horizon. But then, of course, there's just the lurking question about the factual basis. If they have a geofence warrant, they would have a list of devices that connected. Typically, what you do is then you go through and you start ruling out ones that are known. So people that would be there, people that you would expect to be there, friends and family, etc. You would go ahead and identify those and rule them out, and then whatever's left, this is your suspect pool. So you would have this suspect pool of devices that then, once you have Bryan Kohberger's device information, you'd be able to look and see, was he within the geofence at that particular time? And none of that's in the probable cause affidavit. And so we don't know if that means, well, it didn't happen. They just didn't do geofence searching in this particular case. We don't know if they didn't want to rely on geofence data. We don't know if the geofence data was potentially exculpatory, and hence this heavy reliance on cell site location corroborating, fuzzy videos and stuff. This data that is far less precise and a little bit more nebulous gives them a little bit more wiggle room. And so the only real hints we have are the hints from that notice of alibi, that the supplemental notice that Bryan Kohberger filed, where he indicated that according to their defense expert, Cy Ray, there is data that should be exculpatory, and if it is not produced, it is because it has either been it's either being withheld or it has not been preserved. So, tying all this together with today's hearing, I don't have any idea if any of this is going to come up, what the deal is going to be, but that's what's been on my mind, because if there is some exculpatory evidence in the location stuff, that just seems to me like a very logical place to find it. We've been talking about the issue with the lack of precision of the cell site location info, the much greater precision of the GPS data. They have his phone. We know his phone has been dumped. They would be able to get that information from his phone. But there are always issues with, your ability to delete data and stuff. Phones can be messed with. They aren't necessarily going to always be a clean repository of all the information that you're looking for. So it's very common to also go back to the source. We've seen a lot of that, a lot of those warrants as well. But it just does raise questions to me about if there was a geofence warrant. It seems like Bryan Kohberger's device should be in it if he committed the crime. If his device was not in it, pretty good indication that it's not his white car. He's not the one who committed the crime. So I'm waiting to see if we might find out a little bit about that today. Again, this is just my, thinking out loud. Can't even say that this is a geofence warrant, just that it's, it looks like that. It could be that. It's consistent with the possibility of being that, but it certainly could be other things as well. Just not entirely sure what you'd be going to Google for at that particular stage of the investigation, without a specific user and specific account that you're looking for. Now, the reason why the probable cause is still very much a live issue is because it's the basis for all of the search warrants. And that includes the search warrant that they got in Pennsylvania to swab Mr. Kohberger's cheek, take his DNA, and then go and compare that to what they, found, the trace DNA on the knife sheath. So this is why it's very important for the defense to go down this road. I've had a lot of people listen to my analysis about the cell site stuff, the GPS stuff. Why is the FBI not turning this information over if it's so helpful to the state, so clearly inculpatory towards Bryan Kohberger? And a lot of people respond to that, well, okay, but how do you explain the DNA? You can't explain away the DNA. What about the DNA? I have an explanation for the DNA that I am going to be making a video about. I've talked about it online before. It's trace DNA. Trace DNA is very problematic from an evidentiary standpoint. But that's kind of the factual question. That's the question of, is Bryan Kohberger, guilty or not? There is a whole other question of, do they have sufficient evidence to take him to trial? And the defense is going to be thinking about both of these things, because even if they think he's factually innocent and they really want him to be exonerated, you don't necessarily gamble somebody's life on taking the case to trial and getting that outcome. You use every weapon that you have to put him in the best position to get the best outcome. So if they're in a position to be able to move to suppress that DNA evidence that they got from his cheek, the defense is going to do that. Because yeah, let's say the state concedes, we can't put him there. We don't have good location data, but there's still enough for us to go to trial based on this DNA link. And they want to persist with doing that. Well, if you can get the DNA link, eliminated as a piece of evidence, then you're in a much better position to be able to get that thrown out. So that's kind of where I think this might be going. That's why the probable cause issue is still live. That's why they are, focusing so much on what the basis for that probable cause was, what they relied on, how they got there. And, perhaps most importantly, why aren't they showing their work? Why don't they want to show their work? From the last hearing, it sounded like the FBI, they provided their original draft report, but they have not provided the final. That, in and of itself, okay, you can be doing ongoing analysis, ongoing investigation, and we certainly can see just from looking through the docket, yeah, there have been additional warrants gone out, searching for apps, searching for additional things. In a case where, there's very strong corroborative evidence of the person's guilt, then you'd expect a lot of these things to just be, corroboration. They may even not be necessary. Like if from Google that his location history was there, from the cell site location that his phone was generally there. From his phone trying to connect with the Wi-Fi at the house that his phone was there. Then you don't necessarily need to go to TikTok to get all of his all of his account information from TikTok and all of these other app-based services that use location data and that often will pick up additional information about where the phone is located based on Wi-Fi connections, based on Bluetooth connections, and things like that. So obviously a lot of other reasons to look at Bryan Kohberger's TikTok. If you think he's guilty, we're trying to trace down, location with some kind of connection with the victims as well. So social media types of apps would be a normal place to look. But then you have things like, Spotify. I don't know. I don't know about Spotify is not like the socialiest place, but I guess you might just want to know, did he follow their playlist or something like that? Look for a connection. But one interpretation of it is that they have come up short on trying to find location data. And so now they are in the process of kind of trying to parse through the apps to see what they can find and see if they can find some instance where the phone, connected somewhere in the vicinity of 1122 King Road. But we should hopefully find out more today. Now, this is if, of course, the judge lets us see the whole thing, because he has held the door open for potentially closing the hearing back up if something is going to come in that, in his opinion, needs to be sealed. Then he has, reserved the right to basically close the courtroom, kick us out, stop the stream. And I certainly hope that he doesn't do that. My big hope is that he's had a little bit of a change of heart about his initial knee-jerk reaction to close the hearing off entirely anyway. It's just for reasons I've talked about, reasons I wrote about on my Substack. Lots of reasons. You should not be closing the courtroom except in the most extreme circumstances. It's too fundamental to the process for it to be open to the public, for us to be aware of what's going on, and particularly when that relates to fundamental government activities like prosecuting people for capital offenses and how they're handling discovery and whether they're providing it, whether they are behaving in the way that we expect good, diligent, truth-seeking, ethical prosecutors to behave. That type of thing should fully be on the table. And I say that not because I'm suggesting, or implying that Bill Thompson has been other than that, but it's really to his benefit too, frankly, for people to be able to see this is how you're performing your job and to be able to judge that accordingly. Because yeah, if the defense is overreaching, the defense is asking for stuff that they're not entitled to, well, you want a prosecutor who's got a spine and is going to stand up and protect the privacy of the people implicated, protect that information, protect the process. So it's I just pointing out, I don't say that to be critical of Mr. Thompson in particular, but it's fundamental to being able to evaluate how your public servants are doing in their jobs. Well, I'm kind of frantically refreshing the page over here because I don't know why I have some difficulty with getting the live to go live because Judge doesn't keep the streams. He doesn't archive the screens. They're not available, and so they sort of come up and then play and then they vanish, and are hard to find. So I got to kind of catch it right when it goes live. He doesn't seem to pre-create it in a way that I can go in and just have it going. And then when they come on, they come on. But it doesn't look like they are in yet. So if anybody does see otherwise, please let me know. But so far, it looks like we are still waiting for them to get started. And that's, consistent with them if they need to be setting up Zoom links and things like that. That's not really all that surprising. So, yeah, fourth and fifth motion to compel. We had the fifth motion get filed shortly on the heels of the fourth. The fifth, we know some of it has to do with the investigative genetic genealogy also, but we're not going to get to know anything about that. That hearing is going to be closed. That part of the filing is going to remain sealed and so forth. But at least a portion of it is continuing to deal with this same presumably stuff that is going to the location analysis, the location data, and the things that are potentially going to support or rule out the alibi. Bill Thompson has challenged the defense on the alibi. And this is, I just want to say it is a little bit troubling to me, just from a kind of standpoint of being a justice seeker. It's very clear that from Bryan Kohberger's standpoint, these cell site and location-based analyses are really central to being able to establish the alibi, because that's what the evidence is going to be. He says he was by himself. He doesn't have a witness who can say, yes, I drove with Bryan Kohberger to Wawawi Park. Oh, they're going. Let's go.
On record, please.
And here we are. So he is going to be there live.
Okay, we are now on the record. This is State versus Bryan Kohberger, CR 29222805. Mr. Kohberger is here in the courtroom with his attorney, Ms. Taylor. The state's represented by Mr. Thompson and Ms. Jennings, Latah County Prosecutor's Office. I believe Mr. Logston is remote, and so is Ms. Matha, both representing Mr. Kohberger. I think I've covered everybody. Ms. Evans is the court reporter. We're here for a motion and a potential witness, I believe, relating to motions to compel discovery, fourth and fifth. That's all I know. Okay, go ahead, Ms. Taylor.
Your Honor, the court is correct. We are here to begin the motions to compel. We have testimony today from Detective Mowry. As the court will recall, he's unavailable on the 30th and 31st, which are the days when we will have the full scope of our motions to compel. So it may feel a little choppy, but we would like to hear from Detective Mowry today and would call him when it's appropriate.
Okay, thank you. Anything preliminary, Mr. Thompson, Ms. Jennings?
Okay.
Okay, great. Detective Mowry, come on up. You face the clerk, raise your right hand.
Do you solemnly swear that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
All right, thank you, sir. Go ahead and have a seat there. If you're seated, please state your name and spell your last.
My name is Lawrence Mowry, Mowry.
All right, thank you, sir. Ms. Taylor?
Thank you. Will you tell us how you're employed?
I'm employed with the Moscow Police Department.
What is your role there?
I am a detective.
How long have you worked for Moscow Police Department?
I've worked for Moscow for over 5 years.
Have you been a detective that entire time?
I have.
And prior to that, did you have law enforcement experience?
I do.
How many years total?
We have on 14.
Detective Mowry, did you take part in the investigation into the homicides on King Road?
Yes,
And what was your role?
a lot of different things. How to answer that.
Well, I can ask you about a couple of roles, maybe.
Sure.
Not
Do
being super
you
cooperative.
do any work with cell phones and cell towers?
I have taken training for cell phone analysis.
Was that one of the roles that you played in this investigation? All right. And the other area that I'd like to talk to you about is the collection of videotape evidence or surveillance evidence from around the community. What was your role in that?
So we gathered a lot of data, a lot of USB hard drives that came in. At one point, all of that was given to me so that I could copy it over to a server. So we have it stored and backed up.
Did you inventory it at that time as you got it in, I guess?
Don't have to say inventory. I used the evidence technician to help me book them individually at the time. Right, so the USB had the name of it on it. I would label the folder of what it was, and that came from it.
Did you have any role in verifying the content of the surveillance?
No.
I'm going to have a few questions about that, but I want to talk a little bit more about your role with cell phones and cell towers. So let's start there, okay? What training do you have for that role?
So some time ago, I went through what they say PATC training, which is cellular analysis, and I've also taken classes with CAS codes.
The cellular analysis, is that particular to the device itself, the cell phone device?
No. That
Is particular to towers?
To the towers and the providers themselves.
When did you take that training?
Well, the CAS, I believe it was in 2019, and then I also did it again last year.
And the CAS that you took in 2019, that was the ENDICAC, is that right?
That was predominantly again, correct?
And the CAS that you took last year was October of 2023, is that correct?
Yes.
And that was the actual CAST training.
They were both done by actual cast members. I'm not sure if one was sponsored by the other, but they were both performed by FBI cast members.
And Your Honor, if I can approach.
Yes, thank you.
Detective Mowry, I'm putting in front of you what's labeled as Defendant's Exhibit O, and those are 2 certificates for training. Is that correct?
Yes,
All right. The one that's from 2019, what did that cover?
that covered the use of the Cascos software.
And what did the one in 2023 cover?
The second,
Your Honor, I move for admission of defendant's oath.
The objection?
No objection.
Okay, those are oh, no objection. Thank you.
The Detective Mowry, how many total hours do those certificates represent of cast training?
I apologize, I didn't look, it was a week long, but it was actually a couple of days each time. 2 days a piece of
Do you
please.
need this?
So the 2019 shows 24 hours, 2023 says 16 hours.
Thank you, Detective.
Thank you.
Detective, you've written some reports in this case, is that correct?
Yes,
I want to talk about two particular reports right now. One is from May the 5th of 2023. Do you recall that report, or should I bring a copy of that to you?
it'd be helpful to add a copy.
I can definitely do that.
I am sure she came prepared.
You can show it to Ms. Jennings.
We have a jury next door,
Okay.
just so you know, that's all about.
Detective Mowry, does that appear to be your report from May 5th of 2023?
Yes,
And Your Honor would move for admission of defendants P,
That's P,
like Paul?
all right, any objection? Okay, thank you.
Yeah.
Exhibit P is admitted, no objection.
Thank you, Your Honor. Detective Mowry, I do not have a police report for the other one that I want to talk about today. It's one that I received via email today that was written just within the last few days by you, probably. Do you know what report I'm talking about?
yes.
Okay. Now, what I want to understand is we're talking about documents or records or logs that can be created by a CAST Viz program. The report that you wrote that I received today, when did you learn about those documents that exist according to that report?
The session logs that I found were from yesterday.
Why did you come to find them yesterday?
I was preparing for this hearing.
Okay. And those are things that existed for quite some time, is that correct?
They did.
And when you wrote about your work with CAST Viz in May of 2023, did you document those items?
No,
Tell me what you found when you were preparing for the motion to compel today.
I found session logs that were sent to me from the FBI.
All right. And in those session logs, how many files were there?
I don't remember, I think there were 6 or 7 different items inside.
Did you look at the CAST Viz 48-hour file?
I don't remember if I did at the time of reception.
Did you look at it yesterday in preparation for this hearing?
I attempted to.
All right. And how about the CAST Viz full log?
I attempted to yesterday.
I noticed in your report that there were several items that you listed. Were those from these CAST Viz logs that you attempted to look at yesterday?
I'm sorry, I'm gonna have to, you need to speak up a little bit. Or just telling me to pick up a little bit. Thanks.
There were some files that were in the session logs, there were other files that were not.
Well, let's start with the 48-hour. What was contained in there?
There's over 48 hours that was the AT&T records, the original records. And there's a 48-hour session log. I don't know which one you're at.
Let's go with the session log. What was in there?
Appeared to be the AT&T records that possibly were inputted, as well as some JSON files that were probably produced by Customs.
JSON files were produced by CastBiz. Is that right?
I would assume that. I didn't create those files.
What date were they created?
I believe one was in December. The other was in April.
December of what year?
22,
And April of what year?
23.
Could you tell who created those?
I could not.
How did you get those?
I was provided those via email.
By who?
I made balance of the FBI.
What did you do with those?
Gave them as soon as I realized they were in my possession, I had contacted the prosecutor and gave them.
And that would be just yesterday, is that correct?
Yes,
What did you do with them prior to that time?
they were sent to me. I put them in a folder and I didn't do anything else with them. That's why I forgot them.
Okay, and that was the 48-hour file?
48-hour session log, yes.
How about the full file? What was contained in there?
Similar items to the 48.
What is the full file?
I believe that was the second AT&T return that we got via warrant. I wasn't able to open it to verify it.
That brings up a question for clarification. When you say second warrant return, are you talking about something that relates to Bryan Kohberger?
Yes, there was 2 warrants that were originally written, one that covered a 48-hour period for the cell phone number, and there was one that was later done for a longer period of time.
And those are what you're referring to as the warrants 1 and warrant 2?
Correct. One for 48 and one for the longer period.
In the report that I just received today, there was reference to a loped bar file. What's that?
It is a file that I received from Agent Balance.
When did you receive that?
Honestly, the modification date or the email, I honestly don't remember. Unfortunately, it was yesterday and I didn't throw this stuff together, so.
Okay. So that was one that you just found yesterday?
Yes,
Okay. Did you open that?
I don't recall opening it. If I did, I don't recall doing it.
How about the CDR.xlsx file? Was that, and CDR, what does that stand for?
All retail records,
Did you open that?
I don't remember if I did not.
Did you open it yesterday?
I don't remember. I was looking for it. Once I found them, I was trying to figure out how they came into my presence or in my possession. That's what I started to focus.
Okay. How about the export.kmz file? When did you find that file?
I had found that one yesterday,
Do you know when that came into your possession?
some time ago.
Did you open that?
I believe I did on my laptop.
What did that show you?
It showed me different locations and so forth on a map.
Those 3 files that we just talked about, along with the CastBiz 48 and the CastBiz full, are those copied so that I can have those now?
Yes,
And you referred to emails. How many emails did you find when you were preparing for this hearing?
I believe there was 5.
Are those included for me to have now as well?
Yes,
Thank you. In the report that I received today, there was a reference to drawings.json file. What's that?
it was a JSON file that was inside the CastBiz session notice.
What does that depict?
It's just data that CastBiz would use, I'm guessing, to replot something on the map to actually show locations or other things.
Did you do anything with that file when you found it yesterday?
I did open that file, yes.
Okay. What did that show you when you opened it?
There were references to 2 locations inside.
When you open it, what Does it just say, here's 2 references, or what does it show you when you open it?
It's different code, but there is some plain language or plain English, plain text inside of that code that show 2 addresses.
Did you use that file? Well, let me ask this first. That file that contains code, do you use that with the CAST biz program?
I attempted to load the session file as it in its entirety and it received errors, so I was not able to. That's why I went into the JSON file to see if there was something I could see reference.
Is that file usable?
I'm sure it is to someone.
What is the restriction for you?
I don't know what restriction it is. I don't know what to do with that file outside of, if I could possibly bring it into the cast is. I tried to pull it in as a combined session log, which is what I was trained to do. So I didn't get that. I didn't pull that file.
Is that file available on a Discovery Drive for me?
I did to the prosecutor today.
Thank you. In the report that I just got today, there's a reference to another CAST biz session and some screenshots. What is that about?
I believe you're talking about just the regular 48 hours folder.
I don't know. I'm curious.
So that I provided 2 folders. One was cast viz and one was just my last name of Maori. That was to differentiate the files that I found that were provided to me and the folder of the files that I use to create this report.
Okay. CAST biz is the files that you found while preparing,
Correct.
and the one that says Maori is what you used to create your May 3rd report of 2023.
Yes.
Okay, I think I understand that now. In that file, I think your report said you found screenshots dated April 19th of 2023.
Yes.
All right. Does that mean that's the day that you put things into your CastViz program?
That was the day that I made the screenshots themselves.
Okay. Where are those screenshots now? Are those also included on the drive?
Yes.
Okay. And then your report dated 5/3 says that you were asked to examine the record. So I'm a little confused if you had something that you took screenshots of on 4/19, but on 5/3 you were asked to examine the record. What were you doing on 4/19 or before to get those screenshots?
So I was tasked, the date was May 3rd for the report. It's not the date that I asked.
Okay. What day were you asked to do?
I do not remember. I'm gonna guess that it was somewhere around April 19th. That's when the screenshots were created.
Okay. Let's talk about that time frame then and what you did. Did you actually use a CastViz program at that time to create something?
Yes.
The CastViz program that you used at that time, and we're talking about springtime of 2023, we'll call it April for now, if that's fair. What training had you received by then to do this CastViz program?
The 2019 training.
Okay. With the CastViz program, what's the first thing that you did?
Once the program is open, you can drag and drop the CDR records into the program.
CDR means call detail records.
Right.
Did you do just 48-hour records or did you do full records in April of 2023?
I only did 48 hours.
When you put the records in, those are the call detail records, and those relate to what?
To the phone that the records were coming back to.
The number you associated with Bryan Kohberger.
Right.
Okay. After you put those call detail records in, do you have to do anything with cell towers?
With the AT&T, no, because the cell tower locations are in the AT&T CDR.
Okay. So you put that record in, the tower locations are already part of the call detail record that you put in.
Yes,
Is that something that you have electronic on your computer and then you open your CastViz program and just import it into the program?
yes, AT&T provides both PDF and text documents of the file, and I use the text document to put into CastViz to have it adjusted.
And when you do that, what gets exported?
Nothing. At that point, nothing is exported or created that I know of.
Can you export the session that you're working on?
You can export a session log, yes.
Did you do that?
No,
Mm.
How did you create screenshots?
by using the built-in Windows snip tool, as well as the built-in Windows game console, I believe they call it the game bar, which is just accessed by hitting Windows G. That allows you to record your screen.
Are those the only two things you did, is screen clip and screen record?
Yes,
How many times did you use call detail records in the CastViz program?
probably a dozen times. I'm not entirely sure.
That was a terrible question. How many times did you use the CastViz program in relation to Bryan Kohberger's call detail records?
I don't know.
More than once?
I recall doing it for the grand jury because I wasn't the main lead in the call detail records investigation.
I don't understand what that means.
I wasn't the main person looking at those call detail records.
You weren't the main person with the call detail records, but you put them in the CastViz program anyway?
For the grand jury, I was requested.
Okay. What did you rely on in producing those? Producing whatever you produced for the grand jury?
Rely on what did I produce? As far as the AT&T records,
I want to know what you relied on to do that, to produce something for the grand jury.
I don't understand the question.
Okay. You weren't the main guy with the call detail records or with the CastViz programming. Did I understand that much right?
There was another investigator that was doing it.
Okay. But you end up involved in it somehow in April of 2023, is that right?
That's when I was asked to examine the data to provide that for the grand jury.
Okay. Was that all of your instruction?
What do you mean by that?
Well, you're asked by somebody else who's actually doing this part of the investigation in the case to produce something for the grand jury to use. And I'm
That's
curious
what the
about
prosecutor-
what you relied on, to get to that point. I want to know all the records you relied on, all of the emails, all of the conversations you relied on to produce this thing that you're not the expert for.
So I wrote the affidavit for the AT&T records, received the AT&T records. Those records were also given to another investigator who was the main investigator doing the CDR records. Prosecution then asked me to provide or create some type of visualization of the call detail records and examine the call detail records for the 4 hours in question. That
Just to be really sure, when you talked about writing the 2 warrants for AT&T, we're talking about 2 warrants that relate to Bryan Kohberger. There were a lot of other warrants. Is that right?
correct?
Okay.
Yes.
I just want to be really clear on that. You've taken the CAST training. Is that right?
Yes.
And you know there's a way to save your session. Is that correct?
Yes.
And there's also a way just to hit reset and delete your session. Do you know that part too?
Mhm.
And back in April, when you were creating something for the grand jury, you hit reset. Is that right?
Or I just deleted the files out of it. I don't remember if I had reset or deleted. You can delete them individually as well.
You don't remember which thing you did,
I do.
but you decided to delete what you'd created.
Don't know, I didn't delete anything. I didn't create the session log, so I don't know how I was doing it. You delete the reference of the file in the software, but the file itself is not deleted.
I want to make sure I understand. The record, the AT&T record still exists. You didn't delete that.
Correct.
But the session, when you put that in to the Cast Viz program, and it does its thing with the call detail records, which includes tower references, you either deleted that session or you chose to reset. Did I understand that right?
Didn't create a session log. I don't know how I would delete it. I just removed the reference to the file, the main file, from the software at some point. I don't know when I did that.
You don't know when you did that?
No, you can close the software without hitting reset or delete.
And then it would just stay there.
I deleted that.
And you can also export your session if you get interrupted and you want to come back and work on it, right?
Yes,
Okay. Did you do that? You left it up and running at some point and then did something that didn't save it. Is that right?
the session log was never created. Did not create a
We
session
got
log.
that.
The CDR records that I was dealing with is relatively small. There's no need to do that because I can ingest the files right back into Cast Viz in a short amount of time.
Your Honor, just for clarity, may I approach? I have another exhibit to show him. I'll give it to you, Your Honor. Thank you. Are you familiar with the document that was handed to you that's marked Defendants W?
Yes,
And have you seen that before?
I have.
Is that something that you were taught from the CAST Users Guide?
I'm sure I was. It's also included in the software that can be readily accessed.
Okay. And Your Honor, would you move for admission of Defendants W?
Thank you. No objection. Okay, that exhibit W is presented.
Thank you.
No objection.
In your training, were you also taught from the CAST Field Users Guide?
I believe so.
I'm about ready to switch gears on you and talk a little bit more about videos for a second, but if I can have just one moment, Your Honor.
Sure. Thank you.
That did not seem to go all that
Okay.
well for him.
Let's switch gears for just a minute. You, during the course of your work, did you make contact with the Idaho Department of Transportation to talk about some of the cameras that cover main roads coming into and out of Moscow?
Yes,
And did you attempt to make preservation of any items? What items did you want preserved?
I was trying to see if they had saved video or still images from those files
What did you learn?
that they do not retain those.
Did you, when you say they do not retain those, do you mean they don't retain videos or pictures or both?
Both.
Did you do a preservation for anything?
Not recall studying actually a preservation letter out.
Okay. Your Honor, if I can have another exhibit provided.
Yes, thank you.
Mm. No preservation letters. Just the kind of cherry-picked video. Not great. Not great. So as far as like the details of these file types and stuff like that, I'm kind of as lost as you guys are. I don't know specifically what all the different
What do you recognize
acronyms
that
mean.
exhibit?
So these are emails that I was trying to find some kind of contact information for windy.com, a website that does weather-related information as well as has some links to images from cameras that are covering the highway.
And did you learn that you could have some still shots preserved?
I did.
Did you have some still shots preserved?
I did not.
Okay. Your Honor, would move for admission of defendants PP.
Thank you. That's what, I'm sorry, PP?
Double P, yes.
That's what I thought. Okay. Exhibit PP is exhibit or admitted, no objection.
Didn't look for any.
When we started talking, we talked about you kind of being the guy that would book or take videos in from different agencies, even if you didn't verify what was on the device you received. Is that right?
Yes.
And do you, I have a specific one that a couple of them I want to ask you about. One is from Red Star Coffee Shop. Do you recall receiving that video?
I did not.
Okay. And are you aware that it was hooked in or brought in by Idaho State Police?
No.
How would I find out about those videos?
I don't know. You would have to go through the USB drives to find out what was given. I was just given the mass USB drives. I was not given them individually by the people that were bringing them in for time. Given to them after it had been handed off to other investigators and other assistants that were helping the house.
Is there somebody else I should ask about specific ones to track where they went?
I don't know. I don't have that information.
Okay. All right, give me just a minute, Your Honor.
Sure.
So here's though what I can gather without knowing.
Thank you, Detective Mallory. I don't have any other questions for now, but hold on, the prosecutor might.
All of the ins and outs.
Taylor. Jennings, Mr. Thompson.
Ms. Jeans.
Okay, Ms. Jennings.
Mallory, I want to go back and talk a little bit about this CastViz. Can you explain to me generally what is CastViz?
It's just a software that is useful in creating visualizations of the call detail records.
Okay. So how is it useful? What does it show?
It shows the location and the direction of the cell towers and their sector antennas.
Okay. Now, what version of CastBiz do you have?
Currently, I think I have 33 on my laptop. It's prompted me to update to 38. But at the time, I believe I had version 30 installed.
So walk me through. You start up the software program,
Yes,
and then what do you do?
drag the text file from the CDRs into the system. It ingests the files and then produces a display of that data.
Okay. And is that what you did?
You need 2 days of training to
On the
drop
19th.
drop and drag.
Yes,
And then what did you do with that visual that was displayed?
those visuals, I created screenshots, created the screen capture of the video. CastBiz also allows a timeline playing view that you can record separate the Windows Code and some software. Save those.
Other than uploading the CDRs, did you change any of the settings on CastBiz?
The only thing that I would have done was gone in and changed made sure that the time was correct because they were coming in from TC. It was a coordinated time. I wanted to make sure that those were representative of the local time.
Alright, so you just changed it to Pacific.
Correct.
Any other changes?
No.
Okay. So you were talking about how it does not automatically save.
It does not.
Okay. And you chose not to save.
No. And in the exhibit that was provided, the actual text says that if you need to save a session file.
And can you tell me why didn't you save these settings?
I was creating the visualization exhibits. That's what I was doing with that.
Any reason to save the settings?
No.
Could this be recreated or redone in the same fashion?
Yes, I can, again, open the software, drag the CDRs back in, and in a very short time it is generated.
And it would give you the same information?
Yes,
Is that why you didn't save it?
yes.
I want to switch over to the other session files that you found. Were those session files created by you?
No.
Okay. And did you ever use those?
No.
And have you now turned those over, provided those?
Yes,
Now I want to switch gears over to what we were discussing as windy.com. What is that? What is Windy?
it's a website that is available for weather and such.
Okay. And why is that relevant in this case?
We were directed by, I think it was Corporal Payne that told me that we should look into windy.com.
And why is that?
Just to see if they retained video from the cameras themselves.
Okay, so windy.com has cameras.
They have screenshots. They basically capture the ITD cameras and put them on their website. Those images are routinely purged from their site for the administration of that.
Okay. And can you explain to me, when are those, you talked about them being purged from their site? What's that schedule?
From going on their website yesterday, it's a public website, so I was able to go back to it. I don't remember exactly. I believe that within 24 hours, it's hourly. Within a week, it's daily. Within 12 months, it's monthly. And then after that, I believe it's I'm seeing probably like 3 months or so.
Can you explain why you didn't preserve those images from windy.com?
When it was discussed with other investigators, we would have only gotten, I believe it was one image per day. Time frame wasn't where we are interested in subpoena detection at once.
So there is no evidentiary value.
And that we,
Okay. And have you since gone back and found some screenshots?
yes,
It's what's available on the publicly available website,
anyone can go to wendy.com and grab the screenshots there.
and you've now done that.
I have,
Anything of evidentiary value?
no,
Have those been turned over anyway?
yes.
I just have 1 second.
Sure.
I don't have any further questions.
Thank you. You do that?
Yes, just a bit. You were just speaking with the prosecutor about the images from wendy.com. And I thought you didn't preserve anything or go back and look at anything during your investigation. Did I misunderstand that?
So yesterday when I was directed by the prosecutor,
Okay, so yesterday the prosecutor said, go look for these things.
yes,
But before that, you and other investigators decided not to. Did I get that right?
with the information that we were given, we were told that there would be a screenshot for the day, if I remember right, the parameters of. We did not grab those because they were not in the. Didn't see that they would be relevant.
But you didn't look back then. You waited until yesterday. Is that right?
No, we looked back then. I couldn't tell you what time. Most of the photos that were taken for the daily screenshot or the daily screenshots were daytime. Middle of the days kind of thing. So we didn't grab those at the time.
Okay, but you did look at the time and made a decision at the time. Do I understand that now?
Yes.
Okay. Back to the cast viz for a couple of questions for you. When you were doing the work back in April of 2023, did you see maps on the screen with the work that you were doing?
Yes.
And you also made a video of that. I want to show you a map and see if it's what I think it is. You have defendants R in front of you. What is that?
Appears to be a screen capture of the cast is software.
Is that a screen capture from a map that you made?
Yes.
All right. Your Honor would move for admission of defendants R.
Action.
No.
Exhibit R is submitted, no objection.
And are you aware that when you can see mapping on your screen on this program that there's a log created? Okay. You would agree that if I were to take the call detail records that have the tower report in them, I would have to have the same cast version you were using to recreate what you did. Would you agree with that?
I have to have, if I took the regular cell call detail records and put them into a different version of cast, are you saying that it would become different?
Well, I don't know. That's a good question. Let me try to be more clear about the one I was asking, and then I like yours. We might talk about your question as well. My question is, and the prosecutor suggested that your work could be recreated. And so it didn't matter that you hadn't saved your session. What I want to know is if I have the 48-hour call detail records that contain the tower list like you have, do I have to have the cast viz program that you used so I can see what you did?
I don't know, because I don't know what the back end of the cast is software does. I'm just using it, so I don't know.
And you were in this cast viz program, at least for a while, creating exhibits that would be relied on. Is that right?
Yes.
On more than one occasion. Is that right?
Yes.
But you didn't save your work.
We did not create a session log. That's even need.
Would you agree I can't see what you did without your session log? Can't examine what you did without your session log?
It's there to create the visualizations for the exhibits. That's what I used as is.
But I can't see what you did. Is that right? Is that right?
No,
No, it's not right, or no, I can't see what you did.
you cannot, but I could take those cell data or call data records, put them into assets again. Results would be what they are because we're still using the same records from AT&T to create
Have you done that?
these records.
Yes.
No.
Thanks, that's it.
Okay, thank you. Anything on that, Ms. Jennings?
Didn't like that question. No, you just get the exhibit. You don't get to see how I did it, how the settings were set up. Nothing like that.
Can we go, why did you pull the CDRs into Castus?
Why did I do that in April? Because I was asked by you to do it for the treasurer.
Okay, is that the only reason you did it?
Yes,
Is that the only time you did it?
yes.
Okay.
That I remember. I mean,
Oh, that makes me pretty.
Follow up on that question?
Nope, thank you.
Okay, great. Can this witness be excused?
Yes, please.
Any objection? Okay, great. Thank you. Appreciate it. Yes, thank you.
Boy, is he glad to be done.
All right, you are excused, but you can stay if you like. Okay, next witness.
Your Honor, the rest of the witnesses will be present and ready to go on the 30th, to the very best of my knowledge. This was the only witness we needed to accommodate with today's hearing. So thank you for that.
Okay, thank you. So we're done for today?
We're done for today, Your Honor.
Okay, Ms. Jennings, agreed?
Agreed.
Okay. Yes, what are you, hold on. Yes, thank you. Thank you, Beth. So I have a whole bunch of documents that it's not clear whether I should sign the sealing or not, because there's no stipulation and there's no hearing, but we're all here together. So can we just go through this and clear it up? Yes? Sure. Sure? Okay, so the first one I have is motion to temporarily seal supplemental response to defendant's fourth and response to fifth motions to compel and motion to limit scope of testimony. And I have not signed that because there was no stipulation or agreed.
Your Honor, I apologize. I thought we had agreed, those have the detailed exhibits attached to them, and I thought we'd stipulated that those detailed exhibits could be sealed.
Okay, well, the addition on that was limited scope of testimony, so I wasn't sure if that was included in our earlier agreement.
Your Honor, that's the state's motion. I know we responded to that, and we did not seal our response to that.
Okay. State is asking for sealing on that. Are we on the same page? You know what I'm talking about? Okay. Just want to know if I should sign this or not.
Well, I'm just not sure. Is there an objection? It's the state's motion to seal. Is there an
Right.
objection from defense to seal?
No, if they want their documents sealed, that's fine. We had responded publicly, and so I
Yeah.
wondered if that changed.
Okay, so I'll sign this. That's one. I just don't want to get in trouble with your arguments about sealing and not sealing. Okay. Just wanna
Don't
be
forget my
very
arguments,
clear
Judge.
on the record.
Thank you for that.
Plus is piling up with the clerk. Okay, next one is also the state's, well, this is the one that's sealed. Got that taken care of. Got another one from the state, a motion to temporarily seal exhibits one of state's second supplemental response, et cetera. Any objection?
No, Your Honor.
Okay, thank you. These titles are getting along, I have to say. Fine. Clear. I think that is one. Okay.
Tell us more about what we're not going to get to see, Judge.
This is the same. I think that's it.
Oh, that's all.
Anything else we need to talk about before we're done?
Nothing from us.
Okay. Well, thank you all. We're adjourned. Appreciate it.
Well. What was all that about? So, here's what we have. We have a witness who has 5 days total of how to use the CAST software, which sounds like it consists of dragging and dropping material into a program. And he is just a user. He is not an expert in the program or anything by any means. He was asked to create reports relating to the grand jury stuff. So this is a program that takes the raw digital data and transforms it into a visualization that gives them a map, so that you're able to see it in graphical form. You don't have to be interpreting like coordinates and things like that. All of this information apparently got lost, or a lot of it got lost and then got refound yesterday, and then was put in a report and provided to the defense. So, bit of a red flag there. Bit of a red flag. Lost it, found it yesterday. It's based on the AT&T records, which is the one they got for the 48 hours. It seems to be the one they're most interested in, is the 48-hour period around the time of the murders. He had some additional files, it sounds like, that he was provided by the FBI. Or maybe he got these records back from the FBI after he lost them. Not entirely clear. He says as soon as he realized they were in his possession, he gave them to the prosecutor. Seems like something you should have realized quite a long time ago. So, he was not the primary agent assigned to doing this analysis. He's the backup guy. It was somebody else doing it. And I think we can read between the lines from the things that he's said, is it was an FBI agent. The FBI was running the cell site analysis, and that is certainly consistent with the probable cause affidavit. We already know FBI's CAST unit was the one who was providing them information and stuff for their analysis. So they went through these different files, the CDR records, the export file, emails. These are things that he has since discovered and now produced. So the defense apparently now has this as of yesterday. The issue is that CAST has a way to save your work so that you can presumably see what the settings were, see what the operations are, you know, whatever type of data like that is going to affect what you get out the back end. He didn't preserve that. What he did is he made a screenshot of what he produced, and then he made a video of what he produced. And his explanation is that that's all you need, because if I give you the data, you can just go and redo it yourself. I don't need to show you my work. That's a bit of a problematic explanation for me, because that's really that's part of the problem. Now, I am not familiar with this CastViz software. I don't know what kind of settings it has. Don't know what kind of parameters it has. I mean, there's I don't know how much of this is automatic, built into the system, how much of it can be user controlled. That's a concern to me, though, because this is one of those programs that sounds like it's a really super objective thing. You just plug it into a computer, the computer runs some math, pops out a result, and that's what you get. But those are often things that depend on what the settings are. And I say this because I know this from the context of DNA analysis, where similarly, you might think it sounds like it's really objective, but a lot of things can be changed depending on how the software is set up to detect and how to analyze things. So, for example, you can change the parameters to be basically more or less sensitive to quantities of DNA. That's the one I remember offhand. So there's basically just different ways you can set it to get different results out the back end. If they can't recreate his settings, if there are settings that can be modified that change the outcome, then that can potentially be a problem. He says he only changed the PST, but we don't know what your defaults are. And if they're not running the same version, don't know if you can still run the old grandfathered kind of operation based on the same data. Well, we know the defense is certainly going to try now. If they've got the raw data, they're going to give it a shot. I don't know why we're focusing on this particular thing, this particular analysis. I have to conclude that it's because that's what went to the grand jury. And so that was what was relied on to provide the visualization of here's where Bryan Kohberger's phone was. I don't know that we can necessarily infer anything about what that says about the rest of the information, GPS, etc., all of this stuff. We know they would have. We know they would have it. If they had all of that other stuff and it all corroborated this analysis, it doesn't seem like there would be that much of a point to be focusing on this analysis, because even if there was something here that was an error, something here that should have been disclosed that wasn't, something even that implicates Brady, if it doesn't affect the outcome, it's harmless. It's harmless error. It doesn't matter. just makes me wonder. It makes me wonder if this cast viz stuff is the best thing that they have. I definitely have to wonder. All that, the prosecutor asked this guy to do it. So the FBI is not participating in helping the prosecutor for the grand jury investigation. We definitely can infer that. Don't know why. Don't know why. Weird that they were very happily involved initially and then dropped out of the picture. I just don't know that I get this sequence of events. Don't know that I get it. The cameras. So nothing retained from Idaho Department of Transportation. So didn't send a preservation, but it's not sure. It's not clear that there would be anything to preserve if they don't store anything. And then the windy.com, they were emailing about that, but it sounds like that wasn't much to work with. And then a Red Star coffee shop video brought in by the Idaho State Police. Don't really know much about that either. Did he have it? Is that exonerating? Is there a reason why that particular one is being discussed? Really, really not clear. Well, I was hoping we might know a little bit more, but I'm afraid that after this I might have a little bit more, I might have some more questions. I might have some more questions. Here's the thing. I see a chat in the comments that I'm going to go ahead and pull up here. Plan as probable cause affidavit and IgG excluded come trial. PCA served to arrest, get DNA to match sketchy touch DNA. That's all they got, need as innocent wrongfully convicted this way. Here's the issue. They can cure the original deficiency if they have since acquired information that would be sufficient to show probable cause, if they got it from independent sources. All of these search warrants to all of these providers, those would be independent sources of location data. And so I guess, unless all of this goes back to the original ping and there's no way to sever that, I think that's going to be the question. If they acquired new information as the investigation went on, such that either they didn't have to rely on the original ping data, or there was so much more than the original ping data that if you simply consider the warrant without the ping data, there is still probable cause to think that Bryan Kohberger committed the crime. If they can do that, then they can just go back and get his DNA again. They don't have to rely on the original tainted search. If that first search is problematic, it's only based on the ping, and the ping is problematic for some reason. Okay, they could get the original one thrown out, but the law enforcement would still be able to go back and just get a new one based on the subsequently acquired information. Unless it's just all fruit of the poisonous tree. I don't know. I really don't know on that one. No question the ping was a big initial, fundamental piece of the probable cause. If you hadn't had that, You know, you're not getting the rest of the stuff. You're not getting the match. You still have the IgG. The IgG wasn't part of the probable cause. So you still have that whole, you know, independent recreation of the touch DNA, the genealogy leading to the touch DNA. So potentially could rely on that. I don't know. I don't know, guys. This is a weird one. Unhung hero. Is this more prosecutor tunnel vision? I don't know. I mean, it's definitely seeming like it could be that way. And I guess a lot of it just depends on how much weight do you put on that statement, this insistence that multiple defense attorneys on the team are telling us that they believe Bryan Kohberger's innocent. He thinks he's going to be exonerated, leading up to he is innocent. There's a reason why they're saying that is more than just because Bryan Kohberger says so. There has to be. Everybody knows that people say that they're innocent when they are extremely guilty. You don't just rely on what somebody says to make representations like that to the court. You can't do that. You will have no credibility when it matters. So they have a reason to think this. We already know so much of this investigation hasn't panned out. The blood didn't pan out. The DNA, the stuff in the car, the connections between the victims. We thought there was going to be, you know, social media stalking and all that type of thing. Didn't pan out. I gotta wonder if the cell forensic stuff is the same thing. It hasn't panned out. It hasn't put him there. Brian's ramblings. It's just so gross to me. They all know ya all. I'm not sure what that means. I don't know. Edward Canonis Doyle. Seems like Ann Taylor is going to go after the grand jury, right? Besides getting the evidence thrown out. They might make another play at the grand jury indictment. If I remember right, though, I think there were time limits on their ability to do that. So it may be too late in the day. It may be too late in the day for them to challenge the indictment. I'm not 100% sure about that. But yeah, if they can, I'm sure that they will. Now that said, what does that get them? It gets them a preliminary hearing. You know, it gets them a do-over, basically. He would continue to still be, you know, he can continue to still be held, be charged on complaint the way that they started it off in the first place. You know, you charge him with complaint, and then as long as you have a preliminary hearing within 40 days or whatever, then you can, you know, you can proceed that way. Don't know if they'd have time to do the convene the grand jury and get it done, you know, before the time period passes this time. They had that time the first time around because Bryan waived his right to a speedy preliminary hearing. It bought them more time, and they went and did the grand jury instead. They would not be doing that this time. They don't need the extra time to get the discovery. They would be getting it done. So yeah, if they want all of this out in public, if they want it all out in public, they want that preliminary hearing. I can't help but notice the change in position here. The tides have turned. Where at the beginning of the case, it was Ann Taylor that requested and drafted a gag order, being, you know, so concerned about the pile-on against Bryan Kohberger in the media and putting, you know, being able to put some kind of a stop to that. To now, it's really the state that's moving more to seal stuff. The state is more interested now in keeping more of this stuff undercover. It doesn't look good. It just doesn't. You would think if they got a strong case, why wouldn't you have it out there? I mean, if the defense isn't objecting, yeah, you put it out. I mean, give the people the assurance that you've got the right guy. It's the defense's job to object, to request that it be sealed, that it be closed off if they're concerned that it being out there is going to taint his right to a fair trial. And they're not raising those objections. That has got to tell us something. The Squid, until there's a logical explanation for how there's no victim DNA found in his car, on his clothes, in his apartment, in his shower drain, etc., I can't believe that Bryan did it. I'm really in this camp for the most part, because I'm not going to rule out that the white car has nothing to do with it. I'm not going to rule out that the time frame could be larger than we think. I'm not going to rule out that it could have been committed on foot. You know, there's no necessity that somebody drive there. There's no necessity that somebody take their cell phone there. A smart person, like we think Bryan Kohberger to be, he's a PhD student, for heaven's sake, in forensics, you would think would know these things. Digital forensics guy is not going to take his phone to the scene of the crime. So I'm not going to rule out that, you know, it is possible. It is possible that the trace DNA on the knife sheath came from direct contact from Bryan Kohberger. You can't rule that out. You can't say that didn't happen. But that in and of itself is not going to be enough for me to convict. That is not going to be enough for me to convict him. Some trace DNA on a knife sheath. It's nowhere near reliable enough to get you there beyond a reasonable doubt, particularly when somebody's life is on the line. And when there is no other corroboration that you can rely on to establish that it's him, yeah. I mean, I think, you know, Mr. Squid, I'm with you as far as until this stuff comes up, I don't believe the mechanism that the state has proposed here. I don't believe the commission of this crime went the way that they make it sound like it did from the probable cause affidavit, that Bryan Kohberger got in his car and drove around and ended up at 1122 King Road and, you know, got on a bunch of cameras on the way there, on the way back, is doing a bunch of turns and loops around the area before he stops, and then commits these murders in a 10 to 15 minute time frame, gets back out to his car, drives away, and then is later picked back up, turns his phone back on, and is picked back up outside of Genesee, Idaho, way south. I am not going to believe, I'm going to have a very, very hard time believing that the murders happened that way for this very reason. Without any type of transfer like that, no detection, no evidence of cleaning, no evidence of, you know, extreme measures would be required to keep that kind of transfer from happening. I just am going to have a very hard time believing that. She agreed to all the seals today, Andrea. Why not object? Well, she has to give a basis for objecting, you know, and I think part of the challenge that they're in right now, if the state wants to seal it, you know, she has to have the pattern and practice has been very much in favor of the sealing and in deferring to these judgments that, well, the documents for all variety of reasons under the Idaho administrative rules shouldn't be made public yet. And some of those, you know, as we remember, are very broad. So she would need like a specific reason why it needs to be out in public. And that's frankly, it's a First Amendment. It's a First Amendment issue. It's not necessarily Bryan's issue. It's really the public's issue. We're the ones, you know, who want to see what's going on in court. We want to see what they're litigating. We want to see what these motions about. We want to see why are there discovery disputes in a capital case. It should be easy peasy. Hand the stuff over. If you need some follow-up, great. Go get it. If it doesn't exist, it doesn't exist. We shouldn't necessarily be on a fifth motion to compel. But the problem is they've established this pattern in practice. This is my reading anyway, and it's going to be hard to get out of that now. It's going to be hard to change course and say, well, actually, I've changed my mind, and I no longer think the justifications that we were using to seal all of this stuff early on, I no longer think that those apply. If there's nothing extraordinarily helpful in it, then maybe just hold that until there's a point where, it really would matter to the defense for something to be out in public. But that's just really my best read on the situation. Ian Kenzel, the state needs things sealed because a case this strong will just blow our minds. Duh. I mean, you can't. you can't make this stuff up. Honestly, it is. It really calls a lot of this stuff into question, and especially because we just heard a hearing that suggests there's some shady stuff. Okay, could be just plain old normal incompetence. You lost the files came back, and this is the only reason why the detective is being very defensive on the stand, because he knows he was negligent and sloppy. That's entirely possible. It's entirely possible. And the state isn't going to necessarily want to broadcast that. Okay, I get it. You don't necessarily want to broadcast somebody messed up on your team. But yeah, if there's so much there, I just don't know why the state would be resisting us knowing that. You would want us to know that. And so this strange role reversal where now the state has put on this hat, like it did with the jury survey of we're the ones trying to protect Bryan Kohberger's right to a fair trial. No, homie, that ain't your role. That is not your scene. That ain't you. That's for her. That's for her to decide. The state should be looking at their constituents. What's going to keep the constituents happy? What's going to keep them confident in the charge, the case, the investigation, the knowledge that the right person has been put away. I understand that litigating stuff before trial is problematic, but that door got blown open early on in the case. I mean, it wasn't a problem until things started to go bad. So yeah, it just really is. It really is suspicious, isn't it? All's well that ends well. Cy Ray is ready for his close-up. Good luck, Bill. Well, yeah, I mean that's the big elephant in the room, right? Cy Ray has been involved. He's got all the stuff that the defense team has. He's going to have cast phys, okay? He's going to be able to do all of this stuff just like the detective is. He's going to be able to recreate it. And so if there are problems, I got to think he's going to find them. He's going to already know what some of those issues are. And so I have to believe that he is providing guidance to them. There's a reason why they are focusing on this exhibit that was presented to the grand jury and the process that led to it. Very possible. I guess we don't know. If he didn't have the data file, then he hasn't been able to try to recreate it yet. And maybe that's going to be the $1 million question. Did he have the data file? Was he able to try to recreate it? And if he did, what did he get? And was it the same thing? And if you go in and you change the settings, what does that do to your results? Did you have to work to get to the outcome that was presented to the grand jury? Did you have to really squeeze that peg, rough up those corners a little bit to get it in that round hole? He's gonna know. He's gonna know. Shonda Tibbs. Nothing to say, but thank you so much for your support. I sure appreciate you, and thanks for your support for the channel. Larry, I hope LEOs looked for stolen videos during, before, and after. Yeah, I mean, that would make sense, right? Nobody would drive their own car to a murder. If you're going to drive, you're already committing a murder. What on earth is a minor question of vehicle theft on top of that? Makes sense to me. It would be very logical. Defense Diaries podcast. We think like defense attorneys. Jurors believe that DNA present at a crime scene is a game, set, and match. Yeah, it's true. And that is absolutely going to be a big part of the job of the defense team in this case, is to establish why that is not the case with trace DNA. So that's one of the things I'm hoping when I get some free time. It's becoming a little bit of a joke, but next week we're off on Karen Reed for the most part. So I might have time to get some more things done. But that has been on my list for quite a while, is to make a video about the DNA and trace DNA, what it means, what the limitations are, and basically try to explain the same type of thing that I would expect a defense expert is gonna need to get on the stand and explain to the jury in this case. Because yeah, they're gonna see DNA, got there somehow. The obvious conclusion is, well, he touched it. Something happened to create a direct contact there, and it simply isn't the case. And that's going to be part of the defense investigation as well, I would suspect, because when you're talking about DNA, trace DNA, the issue is it can be secondarily transferred. It can be transferred from me to somebody else to an object, me to an object to somebody else to an object. I mean, it moves around. There is a lot of foreign DNA in the environment pretty much all the time. And so one of the important things for the defense is going to be, can you establish any possible explanation for how secondary transfer could have occurred? It doesn't necessarily take that many different degrees of separation between, say, Bryan Kohberger and the perpetrator, or say Bryan Kohberger and one of the first responders, somebody who handled this piece of evidence, to create the potential for a secondary transfer type of situation. It can be as simple as Bryan has a student who interns at the police department, and they all handle the same things. Bryan gives you your graded paperback, although I don't know if you physically do that type of thing in college anymore. It's probably all on the computer by now, but you're in class, you touch a pen, you both touch the doorknob. The guy then goes to his internship position at the police department, where he shakes hands with the guy who then goes and collects the knife at the scene. I mean, it's possible. And so looking for those types of potential links, if they could establish explanations like that, it's going to help them. I don't know that it's necessary. I mean, it certainly isn't necessary as a matter of principle to just establish that it's possible. But it's going to be a lot more comforting, I think, to the jury if they can look at an actual scenario and think, yeah, that's possibly, the way that it happened. So I would expect that part of the defense strategy is going to be trying to recreate as much of that as possible. Who did you have contact with? Where did you go? The 48 hours or so before the crime was committed, and just see if it's at all possible to narrow down those networks and see if there's a possible secondary transfer event that can be identified. Ghost Horse became a YouTube member. Thank you, Ghost Horse. Welcome. Appreciate your support for the channel. Shonda Tibbs, document dated 3/22/23 holds the answer to why his car was in the area and who holds the key to proof. Okay. Well, I'm going to go ahead and pull that up. I actually have the Idaho cases of interest here open on my computer because I was just looking at it earlier. And so the 323, you must mean 3/22/23, I think, the stipulated motion. Exhibit B of defendant's second supplemental request for discovery under seal. No, I don't know. It may be that, but I don't know. there are a lot of warrants in this time frame, warrants and orders to seal, and that's what I was looking at. The 3823 warrant is the one that I was talking about at the start of the show. The motion to seal the warrant was submitted on November 30th of 2022, and was sealed on December 1st of 2022, and that's basically all that we know about it, other than it went to Google. It was a warrant to Google, and tells us very little about, you know, what the subject was, other than just potentially private, and would disclose investigative techniques and procedures. So that's the one that I think could hold a key, because that's the one that I think could potentially be a geofence warrant, but I don't know. March 22nd, 2023. I'm not seeing anything filed that day. There's the stipulated motion and the second supplemental request for discovery. So let's see what that's about. Yeah, we don't know, because this is at the point where the requests themselves started to be sealed, so we don't know what they were. Other than that, several warrants that were unsealed, redacted at that point in time. So, not sure what that is, but yeah, I'm definitely interested in finding out a lot more. Tim Harris, is there anything sus about the Uber food delivered 5 minutes before? Amazing coinkadink or one lucky dude? Yeah, I mean, it's hard to fit in. It's hard to fit in the DoorDash, right? We don't know what the DoorDash driver said, who he was, anything like that. Don't know anything about the data. He would, of course, be the obvious suspect you'd be looking at. He's there at the scene in the time frame that you're focused on. He would be the logical person to be looking at, well, was that your car? You would hope that that's been ruled out. I mean, they said in the PCA affidavit that they talked to the DoorDash driver, but is he going to necessarily admit that? I mean, is he going to necessarily admit what he drove? What steps are they going to take to corroborate it? You know, I don't know. I'm going to assume that the DoorDash driver can be ruled out as the perpetrator, just you know, for one reason or another. But yeah, the timing is definitely an issue. I want to know from him who answered the door, who took the food, who got the food. If the order was placed from Xana's account on Xana's phone, is Xana's phone passcode protected? You know, is it something where somebody else could go in and open it up and, you know, be sort of creating a alibi-ish time frame, you know, for the killings based on that, skew the information based on that. You know, potentially the killings could have occurred earlier, but police pushed the date, the time later, because, you know, the DoorDash guy, the DoorDash order was placed. It was placed from Xana's phone. The DoorDash guy, you know, has told them whatever he told them. I mean, I don't know. It's a very strange piece of the puzzle for sure. And whatever way you look at it, either, you know, good luck for this guy that he wasn't, you know, at exactly the wrong time. I mean, potentially. Yeah. Very interested in the DoorDash driver. James Casatelli, is this prosecutor Lally 2.0? I don't think he's Lally 2.0. I don't get that read. Lally, for one thing, I mean, a big difference is I'm not all that convinced that Lally really cares that much about the case. I'm not seeing a lot of care put into his presentation, his putting together of the critical evidence and presenting it to the jury in a compelling way. Haven't seen that from him. I definitely believe that Bill Thompson cares a lot about this case and has from the beginning, not just, you know, because it's his job to, but this is a small town. This is a big deal to happen in a town like this. And it's his responsibility. He's the chief law enforcement officer for Latah County. So it really is his job to help people get to the bottom of that. And when you're a career prosecutor like this, you've been part of the community for however it's been like 20 some years, he's going to take that seriously. So yeah, I think he really does care about this case. But I think there may be an issue with the tunnel vision, or simply the case isn't panning out the way that you hoped it would, but you don't have anywhere else to go. If you don't have anywhere else to go and all you really have is this touch DNA that's driven you in this direction, and then it just hasn't been productive, what else do? You're back at ground zero. You dismiss this case, you got nothing. You got nobody to prosecute. You got no alternative theory. So I think that's the big difference between them. I think that Bill Thompson really does care about the case, where I'm not convinced that Mr. Lally does. But I think that the end result of that might still be similar, in that they're just not potentially putting enough weight on the weaknesses of their case. They're potentially overvaluing the strength of what they have, and how a jury is going to perceive that. Edward Quinones Doyle, Detective Mowry stated having to adjust only the time to UTC to PST without a session log. There's no way to verify he didn't make the time fit the crime. It's a good point. I mean, we don't know. We don't know if he didn't log it, what he did. And we don't know, I mean, yes, he could have done something. He could have done something untoward, that he's now just denying, and there's no record of it. So how is anybody going to prove it? That's certainly possible. But, even a less problematic explanation of just, we don't know what your default settings are. If there's other ways, other ways that things can be set up to create different results, it just calls into question, how do we know then what you did, and how do we know that was the right way to do it? But yeah, you're absolutely right. You can't rule out, if he's not going to have to show his work, you can't rule out anything really, because we don't know what he did. He's just counting on us to go and do it ourselves to see if we can recreate it. Well, Cy-Ray is going to do that. We know that he's going to do that. So if it continues to be an issue, I think we can be pretty confident that Cy-Ray wasn't able to recreate it. If it's no longer an issue, then probably he was able to. So we'll just have to see how that unfolds. Lousy David became a YouTube member. Welcome, Mr. David. Appreciate having you here. Appreciate your support for the channel. Shonda Tibbs, red flag. It was unsealed and then went under seal. Oh man. I might have to go back in the memory bank for that. But I'm going to make a note. I'll file it away. The 3/22/23. Go back and see what I can sort out. Mercy Wright, if his phone was off, there wouldn't be a call detail record, and it was my understanding that the 12 pings didn't justify a stalking allegation. So what CDR was he showing the grand jury? Yeah, that is a very good point. The whole issue here has been that they don't have the ping data for the actual time of the crimes, right? They say his phone stopped connecting to the towers at around, what? I forget, it was like 2 in the morning or something like that, in that ballpark. So before they believe the murders took place, and then it reconnects hours later down there near Genesee County, near Genesee, Idaho. So it's not pinging anything. It's not creating records with cell towers. And that's one of the big distinctions between the cell tower and the GPS. Is that a lot of the location services, they're still continuing to work if you're not in cell range. Some of them are even going to work if your phone is off. There's a lot of emergency service stuff that connects with people's phone that isn't necessarily going to be interrupted, even if he did actually shut his phone off and go in and commit these crimes. So it's a good question. I mean, is this just a call detail record of the general thing, the same sort of like general map that they drew out for the probable cause affidavit, that, well, this is where, you know, he went off the signal, this is where he came back on the signal. If Jay Logston was telling the truth about the grand jurors being like, that's it, when they had that motion on what the right standard is for an indictment to be returned, probable cause or beyond a reasonable doubt, he made that comment that some of the grand jurors were like, this is it, and they wanted more. That could be an explanation why. That's all they have. That's all they have is this vague, ambiguous CDR data, and that would raise the $1 million question, because all of these warrants to Google, TikTok, Verizon, etc., the specific stuff for Bryan, they had it before then. They had it before then. So if you've got, they had his phone, you know, they had his phone by then. So if you have all that data and you can extract it and you can plug that, you can plug your new stuff into these programs, you would present that to the grand jury. You wouldn't rely on this vague, ambiguous, nebulous, not very precise CAS stuff that isn't even giving you the information you need for the pertinent time frame. Just raises a million questions about what's there and what's not there. Ian Kinzel became a YouTube member. Welcome, Ian. Thank you so much for supporting. Shonda, just tagged you documents I am referring to on X. Well, all right. Well, then let me get right on over there and see what I can find, because I will be happy to see what we have and what we can share. All right, I'm going to go ahead and share the screen here, and we'll just go ahead and go through this together. Oops, I have this in, hang on a sec. I got to pull this up in Chrome. Wait a minute. I need a new tab. Okay. All right, let me go ahead and share this now. Okay, so up here at the top, here is the document. Certificate of an Idaho judge. Oh, yes. Oh, that's right. Oh, that's right. Yeah. The attendance of an out-of-state witness. This was the process that they had to go through in order to take the deposition of Bethany Funk, the surviving roommate. There's nothing about her, what she saw, anything like that in the PCA, right? There's two roommates that did not, they were not victims, or at least they were not killed. They survived this incident. DM in the probable cause affidavit, Dylan Mortensen, and Bethany Funk. Funky, I don't know how to pronounce it, I'm sorry. But so her statement to law enforcement, whatever it is, did not provide any part of the probable cause to arrest Mr. Kohberger. And in the course of that request, in the course of my investigation, it became known to me that Bethany Funky has information material to the charges against Mr. Kohberger. Portions of information Ms. Funky has is exculpatory to the defendant. It's unique to her experiences and can't be provided by another witness. Eyewitness? Maybe? Maybe she knows who was coming in the car. She knows who the white car was. Yeah. Yeah, that's a very, very good point. I had forgotten totally about that, and I didn't even remember that that's no longer available. So, yeah, big missing piece of the puzzle right there for sure. Yep, Doc 432. Okay, got it. Supportive affidavit signed 3/22/23. Thank you, Shonda. I really appreciate you bringing that up, because, yeah. It says, Bryan Kohberger is alleged to have entered the house around 4 a.m. while 6 people were sleeping present. Her bedroom was on the first floor. She was interviewed by police. She was present at the home 8 hours later when police were called. Became aware that she has information material to the charges against Mr. Kohberger. And so, yeah. So because police arrived or police were called, we can work backwards. The 8 hours back from then is when she was at the house. Do we know what time the police were called? I want to say it was like 11 something in the morning, I believe. Not 100% sure. Well, that's interesting. I will definitely dig into that and see what I can find. Master Nye 666 became a YouTube member. Thank you so much. Welcome, and appreciate your support for the channel. Well, guys, yeah, this is just more, a little bit more confusion, frankly. You know, it would be nice to be getting a lot of these questions answered at this point in time, but it doesn't look like they are going to give that to us. It's just going to continue. It's going to continue to be just very drips and drabs and pieces, because we're not allowed to get the big picture at this point in time. But I'm very glad at least that, you know, we didn't get the hearing shut down. We got to hear as much as we got to hear. And I am also a little bit pleased to hear Judge taking the position with respect to sealing documents, that he is not eager to do that without a stipulation from the parties, because it suggests to me he may have reconsidered his, what I think is perhaps a knee-jerk reaction in favor of secrecy. The Idaho rules in general are a lot more favorable to sealing stuff than, I mean, there's no specific, very little specific case law in Idaho about hearings. That stuff all comes out of the First Amendment case law and the Sixth Amendment case law. A lot of that, you know, at the federal level at the U.S. Supreme Court, then just trickles down to the state level. So in general, you know, the Idaho rules are a little bit more tolerant to closing off portions of the court file. We don't necessarily have that same link with the First and Sixth Amendment stuff to be able to go through the court file as much as we have to be able to sit in the courtroom while the hearings are taking place. So if he's being cautious about sealing documents where they seem to have at least a certainly under the rules, a lot more discretion to do it, then it gives me hope that he might be a little bit more cautious about the prospect of closing hearings off as well. And frankly, I kind of hope the defense maybe stops stipulating so much. And like was pointed out earlier in the chat, yeah, maybe it would be good to go ahead and start objecting to some of these. Make a stand. It's time for us to know what's going on. We would certainly like to be filled in. Definitely, if there are reasons we should be skeptical about this investigation. See, it doesn't impair Bryan's right to a fair trial to put out information that leads people to be skeptical. That's actually very consistent with his right to a fair trial, because he is entitled to his presumption of innocence. People should be going into that courtroom thinking Bryan Kohberger is innocent and prove it to me otherwise. That should be the default. So frankly, anything that can kind of reset the clock on that and get us back into, at the very least, more of a position of neutrality, but really it should be a position of skepticism. We think he's innocent until you can prove to us that he isn't. I tend to have a hard time seeing how anything that tends to undermine this investigation is going to be a problem from that respect. It helps it. It helps it. So, yeah, it's a double standard. But that's the whole point. That's the nature of the criminal process. It is a double standard. The state is the one that has the burden, and that's why they have to be able to meet it, because we don't like putting innocent people in jail. That's not what our society is built on. So, yeah, hopefully that was a good sign for things to come with respect to greater transparency in the case and being able to learn a lot more. But in the meantime, I guess we're going to have to wait till next week to get some more details and see if we can fill in some of these gaps, get a little bit more information about what's going on and what is the status here. Do they have him pinned down on the location or don't they? I think it's such a critical component to this case that if they have it, that's pretty good. That's pretty solid. It's good corroboration of the touch DNA. But if they don't have it and all we're relying on is the touch DNA, then yeah, we need to be probably having some serious doubts about whether we have the right guy here. So just one final comment here, Polly Claire, that was amazing. Andrea, chat has fire wit too. Yeah, thank you. This is a great chat. Really appreciate you guys. I'm gonna be going back because I can't read through everything as the stream is going. But this is one I'm gonna go back through and read everything, because there's so many knowledgeable people in here, so many things to share. A lot of people who have been following these details and really breaking down a lot of this information. So I'm gonna see what y'all brought me. I'm gonna follow up on it. So thank you so much. Really appreciate your support. Appreciate your contributions. Appreciate your interest in justice. We want justice in this case. We want justice for these kids that were killed. We want a process that's fair. That's, at the end of the day, I think all anybody can ask for. So hopefully we'll see that unfolding, and look forward to more of it next week. God, what day is it today? Today's Thursday. Next Thursday, May the 30th at 10 o'clock, we'll be back for the next hearing on the motion to compel. Hope to see you guys then, and thanks again for being here.